Start. A first information report is not a substantive piece of evidence and can only be used to corroborate the statement of the maker under Section 157 of the Evidence Act or to contradict it under Section 145 of that Act. It cannot be used as evidence against the maker at the trial if he himself becomes an accused, nor to corroborate or contradict other witnesses. It is a cardinal principle of criminal jurisprudence that the innocence of an accused person is presumed till otherwise proved. It is the duty of the prosecution to prove the guilt of the accused, subject to any statutory exception. The maxim falsus in uno, falsus in omnibus has not received general acceptance in different jurisdictions in India, nor has it come to occupy the status of a rule of law. It is merely a rule of caution. All that it amounts to is that in such cases the testimony may be disregarded and not that it must be disregarded. The doctrine merely involves the question of weight of evidence which a country may apply in a given set of circumstances, but it is not a mandatory rule of evidence. Appeal by special leave from the judgment and order dated October 18, 1955 of the Allahabad High Court in Government Appeal number 60 of 1953 arising out of the judgment and order dated July 8, 1952 of the Court of Sessions Judge at Bareilly in Criminal Sessions Trial number 27 of 1952. Daulat Ram Prem and P.C. Agrawala for the appellant, 658 Gyan Chandra Mathur and C.P. Lal for the respondent. 1957 February 14, the judgment of the court was delivered by Kapoor. The appellant, along with one Kudrat Ullah, was tried for the murder of one Sabir. The latter was tried under Section 302, read with Section 114 of the Indian Penal Code for abatement and the former under Section 302 IPC. Both the accused were acquitted by the learned Sessions Judge of Bareilly, but the state took an appeal to the Allahabad High Court against the appellant only, and the judgment of acquittal in his case was reversed and he was convicted under Section 302 IPC and sentenced to transportation for life. Against the judgment of the High Court, the appellant has brought this appeal by special leave. The facts which have given rise to the appeal are that Sabir was murdered on the 11th May 1951 at about 6:30 p.m. The first information report was made by Kudrat Ullah, the other accused, at 6:45 p.m. the same day, that is within about 15 minutes of the occurrence. The prosecution case was that there was an exchange of abuses between the deceased and the appellant near the shop of the first informant, Kudrat Ullah. The cause of the quarrel was that on the evening of the occurrence, while Kudrat Ullah was sitting in his shop and the deceased was sitting just below the shop, The appellant came out of his house, and on seeing him, the deceased asked him as to why he was in such a disheveled condition, which annoyed the appellant and gave rise to an exchange of abuses. On hearing this noise, the prosecution witnesses arrived at the spot and saw the appellant and the deceased grappling with each other. The appellant is stated to have asked Qudratullah to hand over a knife to him, which Qudratullah did. This knife is exhibit first, second, with each the appellant stabbed the deceased and then fled away. Stop.